Good afternoon, everyone, and thank you for signing on today. It is my distinct pleasure to present to you United States District Judge Carlton Reeves from Jackson, Mississippi. Judge Reeves has had a distinguished career both as a student and then as a practicing lawyer, and now as a judge. He's a native of Yazoo City, Mississippi, and his life story parallels a lot of significant events that have occurred in this country over the past 50, 60 years. He was in the group of the first class of integrated students at a school that he attended in Yazoo City, Mississippi, where everything, of course, had been segregated prior to Brown versus Board of Education. So he grew up there. He then went to Jackson State University, which is in the state capital, graduated with honors, and then went to the University of Virginia Law School, where he did very well, came back to Mississippi and clerked for the first Reuben Anderson, who was the first African-American to serve on the Mississippi Supreme Court. He then worked both as an assistant United States attorney in several states in private practice, first with a large law firm called Phelps Dunbar, and then later formed his own law firm. Did a lot of public service work also. I was on the board of the Mississippi Justice Center. And in 2001, or I'm sorry, more recently than that, 6-7 years ago, President Obama nominated Mr. Reeves to be a federal district judge for Jackson, sitting in Jackson, Mississippi. In what has become an increasingly rare event in the United States Senate these days, Judge Reeves was confirmed by a voice vote. There are not very many people who get confirmed by voice votes anymore. Judge Reeves has spoken out courageously about judicial independence, about police accountability, and a variety of other important topics. I also just wanted to say one other thing before I bring Judge Reeves on. I'm about 20 years older than Judge Reeves. And when I was in college and when I was in law school, the man who was presiding where Judge Reeves now presides was a judge by the name of Harold Cox, who was about as far from Judge Reeves as you can imagine. He was a virulent racist. He referred to people who look like Judge Reeves as chimpanzees and baboons. So the mere fact that Judge Reeves has taken the bench and that he's a courageous person is a sign of we've come a long way, but we've still got a long way to go. And with that, I'll turn it over. Judge Reeves, thank you very much for joining us today.
Thank you, Professor Weinstein. Thank you so very much for the introduction, and I do really thank you for the invitation to speak or to talk with or have a conversation with the students here. I'm getting used to these Zoom talks because I don't see anybody out there. Everybody sees me. I don't know when, for example, you may receive or accept a joke the way that I want you to receive it or accept it. I don't know if you're sitting back there saying, "God, Lee, will he please sit down?" But I hope to engage in a conversation today because I'm more interested in hearing about you and what you want to hear from me. I know you all have a real track history of bringing in different people to speak with you from different backgrounds and things. So if there's any specific questions that you have, I certainly don't mind answering those questions that I can answer. Professor Weinstein mentioned that I was unanimously confirmed. It may be that I was confirmed on December the 19th, 2010, 6 days before Christmas, and on a Sunday afternoon. I think it's two judges, Raymond Laude, who sits on the Second Circuit. He and I were confirmed that day, and we chat and talk to one another and laugh about it. We think we may be the only, at least at that time, the only judge to ever be confirmed on a Sunday. You can imagine how many senators are around working 6 days before Christmas, including that Sunday. So that may have been why there was unanimous agreement, because I think they stayed in session 2 or 3 more days that week, because some colleagues of mine, I do know for a fact, were confirmed on the 21st. I can't remember if anybody was confirmed on the 22nd or 23rd. The other thing that I was asked, to talk about some of my life experiences and my work here as a judge. But before that, as I told Professor Weinstein, and I've told other law school students, one of the missions that I have, that I've put on myself, is to encourage young people like yourselves to think about, to pursue, and to accept clerkships. And I want to encourage you all. And I realize law school is a very expensive proposition. And I also know that law firms could help you get out of debt much quicker. And I know that you might have other things that you might want to do. But I want to encourage you all to consider federal and state, not just federal law positions, but federal and state, trial and appellate. For those persons who have the inspiration, for example, to be prosecutors or public defenders or trial lawyers in local jurisdictions, you might want to consider a state court clerkship, a state court trial. And trust me, it will not pay much money on the front end, but huge dividends, I believe, would come your way after having clerked for a local judge in a local state court judge. Think about the state courts. I'm going to talk about the federal courts, but just think about the state courts. We are now in a time where there is a real push and there is real effort, in the federal judiciary, people understanding federalism and pushing, deferring to the states. I'll give you one example that is going to be extraordinarily crucial in the next 2 to 3 to 4 years, because we're in the process of census. Every jurisdiction, the state, county, every jurisdiction in the country will undergo some level of redistricting. The U.S. Supreme Court in its last term basically said it's not a federal question with respect to that is not the concern of the federal courts. Those matters will play themselves out in state court. The state of North Carolina, for example, said that the congressional districts there were unconstitutional under the North Carolina Constitution. I would imagine there are going to be a number of a huge amount of litigation in that area. And people will also, not only just the redistricting stuff, but you're going to be finding where people are going to seek out and look at their state constitution to sort of create more rights and sort of expand the rights that you have. So please, ladies and gentlemen, don't overlook your state courts. There will be, and there are a number of great judges on the state court levels. I think of Anita Earls, who's on the North Carolina Supreme Court right now. And there are other judges, and there will be things that are occurring on the state courts. And obviously we know that the state courts are where all of the criminal law litigation that goes on, much of the civil, I mean, the federal courts only do a sliver of the work. But as I turn to federal court, I would encourage you to think about Article 3 and Article 1 judges. Don't just think about the federal district judges and the judges on the Court of Appeals. Think about the bankruptcy judges. Think about the magistrate judges. There's so many opportunities. I found my experience, I did a state court clerkship, and it was the best first step of my career that I could have had because of that relationship with the particular judge who I clerked for. Because of that relationship and that relationship only, for the most part, it put into play exactly where I am today. That clerkship was so valuable to me. I still have a very great, wonderful sort of father-son relationship and mentor-mentee relationship with the judge for whom I clerk. It was during my clerkship that he decided to resign and retire from the court and go into private practice with what at that time was one of the largest law firms here in Mississippi that was based out of New Orleans. But in leaving the bench, he asked me directly, if I go, will you go? Will you come with me? And certainly because he was so nice to have hired me, and because I did not have any other opportunities, and we may talk about that in a minute. I did not have many other opportunities, but he gave me that opportunity to come clerk at the court. And because to the firm, if I would dare practice at the firm, I certainly felt like I could not turn him down, even though in going to law school and pursuing my law degree, I had no desire to work for a big firm, a corporate firm, doing the work that these firms do, representing the entities that these firms represent. I had no desire whatsoever when I was in law school to even think about doing that type of work. In fact, when I was in law school, I was sort of focusing in and looking at the public interest side of things to do. I did not want to wear, during on-campus interview season, the blue suit. In fact, I would be dressed inappropriately because I have on something other than a red tie, a solid red tie, and I dare wear a blue shirt as opposed to a white shirt. So I had refused to walk around the law school, running around, going from room to room, interviewing with these people who I knew I did not want to work with. So I did not pursue that. But in clerking for Justice Anderson and going to Phelps Dunbar, one thing that I do tell people is that I've learned never to say never. And so I don't ever say never again, what I never will do. But I ended up working at the firm. Returning to the clerkship idea, you have a opportunity to work for some incredible judges across the country. My colleagues and I have been talking over the last several years. So one thing that I've been doing is trying to encourage my colleagues to think about, think about your chambers, diversifying the chambers. And those of you who are first generation, those of you who are LGBTQ, those of you who are African American, Hispanics, Native Americans, you are Asian, you are not out of the process. Females, typically, you know, those who know about the clerkship experience are those who have grown up in homes and who have been exposed to the legal side of things. I realize you are at a great university, and I realize you know, there always push. There's always a push at these top tier universities to encourage students to clerk, but sometimes that focus is limited only on the absolute best students, because every law school, and I say this, I do say that, I'm not just saying this at UCI, Ron, I said this at University of Virginia, I said it at Yale, and I'm going to say it to some Harvard students in a few weeks. I know what these law schools do because I was in law school, and I know that they tend to love to make sure that they have students who get the absolute, if you will let me use this word, climatical experience of clerking at the U.S. Supreme Court. They will put it in their journals. They will splash it across the website, and that's the plum job that they want their law clerks to go. But there are judges all across the circuit courts and the district courts that I think you all ought to be considering. You get an opportunity to do just a ton of work, and you get a chance to do some good work, and you develop a mentor-mentee sort of relationship. With respect to my clerks, we are part of a family, and they remain a part of my clerkship family. And, you know, I tell people, those folk who have a tough experience with a particular judge, it is on the judge because the judge is the one who has gone out and interviewed people and have selected that person to work for them. So if it didn't work out, it's the judge's fault and not the law clerk's fault. So I want to really encourage you all to please think about federal clerkships. And as I was indicating, I've had this conversation with judges. I had the privilege of teaching at one of our judicial schools, and one of the things that I talk to the judges about is you know, thinking about diversifying their chambers, adding diversity to their chambers, diversity of experience, diversity of color, diversity of backgrounds, because that is so very important. And I tell my colleagues, please give that African-American clerk, that female clerk, please give that Asian American clerk, please give that Indian American clerk or Eastern Indian American clerk, please give them the benefit of the doubt that you give white males. This is what I tell my colleagues, because I tell them, do not have the next person paying the price for the other person being not working out so well. So I tell them, if you hire one of these persons in this minority group, a first generation person, and that person does not work out well, please, ladies and gentlemen, as I told them, do not make the next African American, do not make the next female pay the price for the failures of that first one. Because by and large, and I know this to be a fact, because I talk to my colleagues, I know that they have had bad experiences with white males. And I've noted that the next law clerk that they have is a white male. So just give everybody that same benefit of the doubt. So please, again, think about clerkships. How did I get to where I am? I mean, it's a long story, but I grew up in a place called Yazoo City, which is approximately 40 miles north of Jackson. The professor indicated that I was in the first integrated class there. But if you caught it, he said that I am approximately 20 years younger than he. So I want to set this up because Brown versus Board, as you know, came down in 1954. It was not until 1970 that the schools in Mississippi were forced to integrate. It was a case, Holmes versus Alexander versus Holmes County. In your Brown cases, you know, you had Brown 1, Brown 2, all deliberate speed was put in Brown 2, I guess. But Holmes versus Alexander versus Holmes was a case before the Supreme Court in 1969. And it came down in like November or the early part of December. But the schools here were still segregated. And they came down with a decision that told the Mississippi schools, you must integrate now. So those students who were in school in 1969, when they came back from their Christmas break, they were in an integrated setting. Well, that still was not my class. My story is that following fall of September 1970 was the year that first graders started out together in Annie Ellis Elementary. And those students were the ones who were the first to go through 12 years of integrated schools there in Yazoo City and across the state of Mississippi. So I tell people, I knew from day one that the white children in my class were, as I say now, were as smart as I was, and they were as smart as me, not necessarily me being as smart as they were, but I understood that they were just like me. The kids had fun together, the kids played together, but we were in a setting where integration, now I want to be clear, was really the 5 days a week that we were in school during the hours of 8 o'clock to 3 o'clock. On weekends, we didn't really see each other unless as we got older, we were in extracurricular activities. Maybe you might be together, football, baseball, something like that after hours. And during the summers, we were still somewhat separate because we played in two different sides of town. They were in the Babe Ruth League, the Dixie League, and we were on the other side of town playing baseball in the Roy Campanella League. But I decided after going after graduating that I would go to Jackson State University, although Jackson State was not my initial choice. But it was the best choice. It turns out that going to Jackson State was the best thing that ever could have happened to me because I got a chance to learn so much about myself, so much about my history, so much about who I am and who I want to be. And Jackson State, our political science department, the one that was my major, we had a pre-law department, and we had Professor Charles Holmes, who encouraged us to apply to the best schools in the country. He always told us all that all of us will be able to get into Ole Miss and Mississippi College, the two law schools here in Mississippi. He said, so please apply to the best schools that you can go to and see where you can go. And that ended up during the 4 years that I was at Jackson State. Other students who I went to school with, I had a friend who graduated from Harvard Law, a person who graduated from Stanford. I was the third person from Jackson State to attend the University of Virginia. And while I was at the University of Virginia, there were 4 of us in school during that 3-year period with each other. A friend, Georgetown, University of Texas, Emory, Vanderbilt. We were all over. And that's what Jackson State produced, and that's where we were able to do. So I went up to the University of Virginia, coming from the deep South to a place that I figured was a place on the East Coast, because I had politics in my mind, thinking that I'll be close to Washington. I went to Virginia thinking, coming from where I am, I'm going to school on the East Coast. Well, after being there a couple of days, the law school campus is separate from the undergraduate campus. So I decided to just walk around the undergraduate campus to see what Mr. Jefferson's university really, really looked like. And I got to one edge of the campus, and there's this statue of Stonewall Jackson on his horse. And I said, damn, I'm back at home. And I realized then, yes, I was at home. We gave them Jefferson Davis, but but Virginia is, about 70 miles west of Richmond, the capital of the Confederacy. So it really hit me right then that here I am in the cradle of the Confederacy. But that opportunity, again, making the best choices and all that, if I had to do it all over again, that would be the place that I would go to law school, because I had endearing friendships, had a great time. And I will tell you, as I said, I know, there are law schools that are pushing you toward clerkships and all that. And I want to be honest with you, young people. I want to be honest with you. I went to a program at University of Virginia where they were talking about the different types of things that you can get involved in and the types of careers. And we had a World of Law series. And this World of Law series, on this particular Thursday, they were talking about clerkships. And I knew, from having gone to Jackson State, I knew what being a clerk was. I wanted to be a clerk. I knew the power of judges. Having grown up in Mississippi, I view judging as judges are heroes. But for the fact of federal judges, Mississippi would not be where it is today on any level. Because of federal judges, I was able to go to school with white students. Because of federal judges, I was able to participate in elections and vote the people of my choice. Because of federal judges, we were able to do so many things, but it was only because of federal judges. So I knew the value of clerkships. So I'm sitting in this World of Law series, and one of the professors who had clerked at the U.S. Supreme Court at the time, Virginia was on a B mean. So the average grade for everybody was a B. And the professor was talking about what it might take to be a clerk. And he said, he told us, he said, well, if you got below an A, if you got below an A, it's going to be tough. If you got a B plus, it's even tough. But if you got anything lower than that, he basically told us, he said, don't think about it. In other words, and he said, I'm not going to be the one who's going to be pushing you and helping you. And right then and there, I knew that the university did not have my interest, because I had grades. And when he said that, I knew that I was excluded, because I had a B minus, I had a B. I had something lower than a B. I had a C. I had grades. I had grades at that time. So that was my second year. So I knew that they were not talking about me. I had a C plus even. I knew that. So I knew he wasn't talking about me. So right then and there, I decided in my mind, this is what I would do. I will chart my own path and try to find me a federal clerkship, or try to find me a clerkship. And yes, I identified 3 judges that I would apply to. One judge was Judge William H. Barr, Jr., who happened to be from my hometown. I was good friends with his first cousin's son. I did not know Judge Barber. I did not know him, but I knew his first cousin's son. We were in the class together from 6th grade through 12th grade. I said, he's from Yazoo City. I'm from Yazoo City. That's the connection I'll use. So I applied to him. I also applied to Judge Henry T. Wingate, who was the first African-American federal judge here in Mississippi. And he had taught me at Jackson State as an adjunct professor in an intro to law class, I think. And he told us that nobody in this class would get an A. He said, you don't get A's out of my class. You don't get A's from me. Well, I got an A out of his class, and so did the young man who ended up going to Harvard Law School. We got A's. So I said, that's my connection. I know him. He knows me. So the third judge that I identified as the person who I would seek to clerk for was a guy named Reuben Anderson, who was on the state Supreme Court. The only connection that he and I had in my mind, the only connection was that he was African American, period. I did not know him. He had been a state trial judge for the county that I lived in. But I did not know him. Did not know him at all. Didn't know anybody who really knew him. But he had a storied career here. Well, I interviewed with Judge Barber, and he was very kind. I interviewed him in 1988, my second, going into my third year, that summer before my third year. He did not hire me. And I was at home over the Christmas break, my last year in school, and I had gotten a call or a letter from Judge Anderson saying, when you're in town, I would like for you to come by and meet me. I did not hear anything from Judge Wingate's office until probably late February or March of my third year in law school, indicating that he had made his selections and that he would not do it. But in any event, when I was at home that Christmas break, that's when I interviewed with Justice Anderson. And he told me then that I expect to hire you. So when I got back to Virginia, I told people, I think I got a clerkship. I hope I got a clerkship. He said he intends to hire me. I didn't know what that meant. It turns out that, again, not knowing what the process was, I wrote him directly. It turns out at that time, you typically should apply to the clerk's office at the state Supreme Court, and the judges could have their pick of the applicants by seniority. So Justice Anderson was on the bottom pole, and he told me, I intend to hire you. But that was a way of, I learned that one of the other judges, or more senior to him, could actually hire me instead of him. But I'm so fortunate that they didn't. But I did not accept what the people in charge at UVA were telling me at their clerkship program. And I don't want you to accept that either, ladies and gentlemen. I want you to identify those judges out there who you think you might want to clerk for and pursue it. So after clerking and after working at Phelps Dunbar, after clerking, as I said, Justice Anderson, and I'm going to wrap it up in about 3 or 4 more minutes because I do want to hear from you. Justice Anderson went to private practice, and so did I. I had a chance to do some, to try cases, to litigate cases, and eventually I went from there to the U.S. Attorney's Office. Again, met someone, talked to someone, and President Clinton had just become president, and he had the right to appoint U.S. attorneys. The U.S. attorney, the newly appointed U.S. attorney, came to me and asked me if I would consider coming over there to the U.S. attorney's office. I had tried cases. I had had jury trials. Believe it or not, many people in the civil division of the U.S. attorney's office at that time in the early 1990s had not had any jury trials because the United States had not consented you don't have a right to a jury trials in many cases against the United States. Prior to 1991, like in your Title VII cases, you did not have a right to a jury trial. But they did now, but they had not had jury trials. So I came over to the U.S. Attorney's Office, and as the chief of the Civil Division. And I was extraordinarily young. I was 31 years old, but I had the opportunity to do some great things there at the office, provide leadership. And from there, the U.S. Attorney, myself, and one of the persons who we had hired when we were there, Cliff Johnson, who was our healthcare fraud coordinator, who did criminal and civil stuff. We decided we would leave in 2001 and open up our own firm. And believe it or not, it was the only truly integrated firm that the state of Mississippi had seen since the mid-1960s, mid to late 1960s, when Justice Anderson was practicing. He was in an integrated firm. There were 2 black guys and a Jew, but that was integrated. I mean, and then there was one other firm in town, Sweet and Rose, with 2 guys who worked together. But Brad, who was the U.S. Attorney, myself, Cliff Johnson, we reached out to an African American guy. So we created this firm, Pygott, Reeves, Johnson, and Minor, and we did all kinds of work there, representing plaintiffs, representing defendants, doing voting rights stuff, doing election stuff, doing just all kinds, taking the cases that we wanted to take, taking the issues that we wanted to litigate, and we did that. And then this opportunity came to me because Judge William H. Barber had taken senior status, and we had fought. Had been the president of the Black Bar Association, the Magnolia Bar Association. We had pushed during the Bush administration, Bush II. We had taken positions that that president had been too slow, or had not appointed African Americans, had not appointed enough diversity. So we pushed back against the nominees in the Fifth Circuit, including nominees who had been nominated for the seat that Judge Barber held. And it turns out that the nominee for that seat, the most recent nominee, had been nominated in February or March of 2008. The election would be in November. That was too late under the system that they were operating then. Trust me, that system is not in place anymore. But that nominee failed. That nominee never got acted upon. And in 2008, when President Obama was elected, that seat was still open. Judge Barber had replaced the infamous Harold Cox. That's who Professor Weinstein told you. Yes, he called them he called black folks chimpanzees, baboons, and niggers. He said on the record and all that. And that's how black people were treated in his court. But Judge Barber brought back so much character, dignity, professionalism, and everything else back into that courtroom. But after 30 years on the bench, he took senior status for approximately 30 years. That seat was open. Well, that's the seat that the president nominated me for, and now I'm proud to say that I sit in this seat, and I have taken an oath not to ever treat anybody like Harold Cox treated so many people. Because you have to remember, Mississippi's history is so tied to the freedom riders and everybody else. and Judge Cox did everything in his absolute power to make life miserable for those courageous young people who came across the country to help Black folk in Mississippi register to vote and participate in the political process. That just tells you very little about me, but it informs you to some degree, I think, about me. But I want to hear from you all. That's sort of my story. I want to hear from you, though. Are there any questions?
Well, Judge, we've got several good questions. But the first thing is that I want to pass along a personal message to you from a member of the audience named Carolyn Nestor, who is the daughter of Kathy Nestor, who I gather is a lawyer you've known in Mississippi. So I wanted to just start out by passing that on to you. So first question I want to pass on to you is one of the more noteworthy decisions that you've rendered was one, a student said she was very moved by your opinion in Jameson versus McClendon, a lengthy opinion about qualified immunity. And student also asked whether or not that you think that changes in qualified immunity would be better addressed by the Supreme Court or in a legislature. First, I think you should just, for not everyone in the audience has probably read the opinion, so why don't you just basically tell people a bit about that case and what you did.
Yeah, basically, Jameson was a young man who was driving through Mississippi one night in 2011 or 2012, I guess, or maybe sometime later than that. It was later than that. Anyway, he was stopped by police, by patrolman, and the stop was a pretentious stop. I mean, it was pretext. The guy lied to him and said we had gotten a call that you had drugs in your car, and they kept this man on the side of the road for 2 hours, trying to encourage, get him to search their car. He eventually acquiesced and said, "You can search. I don't have anything." They lied to him. As we said in the opinion, they stripped his car down, left him there at the side of the road, basically, to put his car back together again, is the term that we use. But the issue of qualified immunity was a part of it because he sued the officer's individual capacity. And we issued the decision in July, about a month and a half ago. And in there, we talk about the history of qualified immunity. Qualified immunity now appears to be absolute immunity because you have to. It's just an impenetrable barrier that one has to reach to sort of take an officer outside of the realm of being protected for all kinds of misconduct. And there was nothing that was legitimate about what this guy did. It was a proper stop, and there was nothing wrong based on the law about any of the other stuff that he did. And we went through the history of qualified immunity. We went through the history of policing. And in studying it, you realize that this is a doctrine that has been created whole cloth by the Supreme Court. This whole notion of qualified immunity, it was not part of the common law. They created it. I think if Congress had the opportunity and could do it, it would be a better fix because it'd be tied to statute or something like that. But the Supreme Court could reevaluate, and there's been a push, even among members of the U.S. Supreme Court, to sort of we need to look at this stuff carefully. We need to reconsider what we've done. It's come from Justice Thomas to Justice Sotomayor. So there is something. I think the Supreme Court, though, has been giving the really trying to give Congress the opportunity to fix the thing that they created. I mean, it wasn't Congress that did it, because Congress enacted Section 1983, and they said what they wanted to say about your immunities and your causes of action under 1983, and qualified immunity was not put there. So it seems to me it's easier for the Supreme Court to take it out rather than wait on Congress to fix what they've done.
Thank you. Thank you, Judge. I would just encourage everyone in the audience, you can find this decision just by Googling it, Jackson versus McClendon. It's long, but it's a very educational and moving decision. Next question is from our a pro bono coordinator, who is, every spring, some students from this law school go down to Mississippi and do some work with agencies there, Mississippi Justice Center, legal aid people. And the question here is, what do you think are the most important issues regarding access to justice in Mississippi now? And what kinds of things can law students do to help with those problems?
The primary barrier to access to justice is finding a lawyer. That's the primary barrier. Of finding a lawyer who would advocate on behalf of those who cannot afford it. Access to justice is the biggest barrier is trying to find people who will accept cases that they may not get paid for, that might take a lot of work to do, and there should be, the legal services program, for example, which is a program I'm sure you're familiar with, Professor Weinstein. It was a big program in the early 1970s when it was created, up until the 1980s, when they, first of all, stripped away the things that they could do. And then after, they could not do the class action litigation, they could not do the voting rights litigation anymore. They could not do the litigation that resulted in fundamental change around it. And then the second thing, they starved it to death. They did not support it with money. So there needs to be a sort of a peace court type of movement to usher in these public interest lawyers and make sure that they can practice without the huge debt and stuff that they, many students absolutely cannot do this type of work because they can't afford to. So the biggest barrier to access to justice is finding lawyers for people in the civil litigation arena because they face circumstances just as dire as criminal defendants. People lose their home. People get their children stripped from them. They lose a whole lot that is tied to them in the civil arena. And we have to do more to make the protection of your rights more accessible to everyone.
Very good. You spoke at some length earlier about the need to, you've been urging your colleagues to diversify the ranks of their clerks. One member of the audience picked up on something from a current event recently, the death of Justice Ginsburg, and there were photos of Justice Ginsburg, being honored by her clerks, standing on the steps of the court and so on and so forth. And a member of the audience said it appeared that almost all of those clerks had been white, and were wondering if you had any thoughts about that.
Yeah, I think obviously when the light is shown on anybody's life, you're going to find a blemish or two, or an Achilles heel. And I think that was her Achilles heel. I think that was a blemish. I know she's had at least one Asian clerk, because Justice Luke out there in y'all Supreme Court was one of her, Goodwin Liu was one of her law clerks. And I think her only African-American law clerk is on the Ninth Circuit. And I can't think of his name, escapes me right now. But I think I've read where in 40 years of being a federal judge, that was her only African-American law clerk. And that does not, although she had many females and men, I think she was deprived of the opportunity to at least be. She was deprived of the opportunity to at least have that experience of having her thought processes and all of that stuff come through the experiences of persons who are diverse, and particularly African Americans. So I think when a full story is told, that side of the story is going to be painful to read, I think.
Right. One member of the audience who herself was a law clerk in D.C. Points out that the judge who's now on the Ninth Circuit who clerked for Judge Ginsburg, his name is Paul Watford, who we've had speak at the law school a couple of times. He's a fine fellow, and I thank Stephanie Wilson for reminding me of that. I think we have time for a couple more questions that have just come in. One is, remember a student asked, says, thank you for coming. Wants to know, during your time as a judge, what do you think is the most insightful observation you have made as a judge, whether it's something about the law or something else? It's a very open-ended question.
I think this will help you all as lawyers. I think far too many lawyers don't listen. They hear, but they do not listen. And while trying cases, you need to listen. Sometimes you may be distracted with thinking about what your next witness is going to be, but far too many lawyers don't listen. And that is what I found. Second thing is, writing is absolutely essential and critical in any phase of the law. You may never write an appellate brief, but your written product is what we operate on, even in the trial court. So work on your written product, because that's what we see. It's the same way when you were applying to law school, and as you apply to these clerkships and apply to these firms, they're going to take your written product first. That's what they're going to see. Just like in your motions and your products that you do here, we don't ever see you. It's rare that you come to court. We operate on ruling on the motions. So listening while you're in court, but also giving us the best written product when you want to get our attention, or when we require you to get our attention.
Thank you, Judge. Music to my ears on both counts. Final question comes from a professor at another law school. It's a very good question, which will require you to give a little bit of an explanation. It goes back to the Jamison case. And it talks about the manner of your presentation in the Jamison case, which is, again, the reason why I urge everybody to take a look at the case at the beginning, because the beginning is very unusual. It has a sort of visual design approach, including a footnote for virtually every sentence talking about historical events. And the questioner wants to know, what prompted you to present the material in that way, which was unusual?
The material opens up with about, I can't even remember the number of footnotes, 13 or so, or maybe even 17 footnotes identifying many African Americans who had encounters with the police officers who were dead. The opinion took a long time to write. We were thinking about it here, and when I say we, I accept my law clerks for helping me do these things and to think about creative ways to get folk attention. If you'll note in the opinion, summary judgment was granted in a portion of the case in 2018, I think. So the other portion of this case we were thinking about it for a very long time. We really started writing it in about January of this year, and thinking about it and really ready to move forward. All of the discovery had been done. And during COVID, this is one thing that inspired me. During COVID, my family had begun to do Zoom calls so that we could be in touch with one another. And it was just something that that my sisters decided that they would do. We would meet on a call with our nieces and nephews, our children, and we would just see how's everybody's life going. And then so in one of the early calls, we started the Zoom calls, I think in May, right around the time of the George Floyd stuff. And my nieces and nephews, I have several of them who live in Texas, and they would come home. Seth lives in Dallas, and to get home, you travel I-20 West, and or I-20 East, excuse me. The other lives in Houston. To get home, you literally drive I-10 going east. And my nieces and nephews, my niece who travels sometimes with her very, very small children, 2 small girls, she travels alone sometimes because her husband works, but her husband's father is a former police chief in my hometown of Yazoo City. So former police chief, he grew up in law enforcement, so he knows. My other nephew and his wife live up in the Dallas area. But they started telling me on this call about all the times that they are stopped by police officers. My nephew's wife has been stopped in her neighborhood several different times. My nephew describes the times that they are stopped. He tells me how emasculating it is. I've been stopped before, but I've never been really antagonized. And I don't want to say that I have been. But he talks about the experience of having his manhood stripped from him because he has not done anything wrong. And he has nothing illegal or anything of that effect. My niece tells me that she stopped with her small children, one of whom is 5 and the other is 3. And the officer is pestering them about letting me search your car. What's in your car? She says, I don't have anything here with my 2 small girls. So that inspired me to think about how this affects everyday people and that our children are facing these encounters every day, even though I have not. And you would think that you would think that those things do not happen. So as I tell people, and growing up, we used to study judges in high school, and they talk about judicial realism, and you think that judges become these different people because they put on these robes. Well, I tell people that you accept judges through the prism of their life experiences. And so my life experience includes the experiences that my nieces and nephews have experienced, that I've seen. And so the George Floyd stuff and all that, because by the time the decision came out, you saw that the names mentioned were dated. It did not include Daniel Prude, for example. It did not include the next person. It will not include the person who is accosted tomorrow, because this happens too frequently, all too often. And so I do think that, and the opinion itself got the attention that it did only because you had you thought the Arbery case was it, which happened in February. It came to light in late, I guess it was April. And then you had the George Floyd. And then you thought that might have been the end. But I've had this conversation for 3 or 4 years or more since being on the bench, because I remember talking to my bar association about what I believe is the worst case that's out there. And that's the Tamir Rice case, where the 12-year-old kid is just playing, just being a 12-year-old. And how an officer immediately jumps out of his car and in a matter of 3 seconds or less kills his child. It's just inexplicable to me. And so, so in thinking about how to address Jameson and all those issues there, we wanted to tell that story and tell it from the perspective of not only of Mr. Jameson, but also of those persons whose names are not called often. And so we wanted to give them their names back. We wanted to make sure that the world knew about them. If you'll note in the opinion, I think it's footnotes 9, 10, 11, 7, 8, 9, we mentioned the names of some kids here who were killed at Jackson State 50 years ago by the police. Their names were mentioned because that is rooted into the history of Jackson State and the Jackson community right here. And that happened, as I said, 50 years ago. Emmett Till happened almost 70 years ago. It happened, and it is still happening. And, you know, it does not end with George Floyd, as I said. It is still happening every day. And so that's what sort of inspired me to at least sort of think about a framing, because it came out of what I heard from my nieces and nephews on that Zoom call, thanks to COVID.
Judge Reeves, thank you very much for joining us, and particularly thank you for that very moving and lucid explanation of the way you put that decision together. Again, I would urge everybody, when you get some time, to read that Jameson decision, or if you can't find it, just send me an email and I can send you a link. And I hope that when we next are able to send some students down to Mississippi on the spring break, that they'll be able to meet you in person. But again, we have to conclude because students have to take their next class. But thank you very much, sir.
Well,
we're deeply appreciative.
Well, thank you for having me again, and I appreciate you. And I hope to see or come in contact with some of you all when you become law clerks for me and some of my colleagues. So, Ms. Nestor, please tell your mother, Kathy, that I said hello. Good friend of mine, so I appreciate it.
Good afternoon, and thank you very kindly, sir.
All right, thank you.
Take care.
All right.